Doesn't it come to your Lordship's mind that when this Article 370 was enacted by the Constituent Assembly, did they proceed on an assumption? This is what I'm important to say. Did they proceed on an assumption that this Constituent Assembly of the state of Jammu and Kashmir will recommend to the Union of India to do away with 370 so that it completely integrates? It could not have otherwise because of the instrument of...
I have some reservation on the use of the word completely integrates. Integration has taken place in terms of Article 1.
Integration. I said complete integration.
No, probably what our clause 3 says is Articles 370, which is a special provision, can be abrogated, can be modified, and or made applicable with exceptions. That's all. Integration is, as far as Article 1 is concerned, is complete.
Can we divorce it from the context? We're going simpliciter as on today. In 2023, it's easy to say so, sir, with respects that it simply says we can get rid of this Article 370 because it is flexible in terms of one part of clause 3. That's what my lords are saying. But it has a context. I'm more on the context. I can divorce it from the context in order to appreciate and understand it.
Anyway, please continue.
In that context,
you understood.
It cannot be done. Of course, if you divorce it from the context, then of course, just like your lordship is saying that this is temporary. Why are my lords saying it is temporary? Because Part 21 says it styles itself as temporary, transient, and special provisions. Therefore, it is temporary. Why did you put it in Part 21? The marginal note of Article 370 says it is temporary. So, therefore, on these two facts, my lord is saying this is temporary.
You know, Mr. Shah,
yes.
One thing which is very clear is that there was no conditional surrender of sovereignty to the Dominion of India. The surrender of sovereignty was absolutely complete.
Yes.
And once the sovereignty was unquestionably and fully vested with the Dominion of India, then the only restraints which would apply would be on the power of Parliament to enact legislation, so on and so forth. A few restrictions which remained, which were also then, as we have seen, subsequently modified. And in fact, there's in the Constitution Application Order of 1972, which is CO 93, which we'll find at Volume 3, page 52, the very interesting provision which comes in 1972. In 72, Article 248 was amended in relation to its application to the state of Jammu and Kashmir. And 248 was substituted, which provides for residuary powers of legislation in respect of all other states. 248 reads with entry 97. Now it says Parliament has exclusive power to make any law with respect to prevention of activities directed towards disclaiming, questioning, or disrupting the sovereignty and territorial integrity of India. Therefore, the order of 1972 makes it now beyond the pale of doubt that sovereignty vested exclusively in India, and therefore no vestige of sovereignty was retained post the instrument of accession.
May I submit to lots of this?
Is it correct that Article 248 now applies, 248 as it is applicable to the state of Jammu and Kashmir immediately before 5th of August 2019, contains an absolutely clear and unequivocal acceptance of the sovereignty of India?
I may respond to my lord's observation. First is the instrument of accession.
Page 52.
First, when there was instrument of accession, one legal question for my lord's consideration is this. When you accede, this was a general instrument of accession applicable to all the states. When you accede, do you transfer your sovereignty to the union or not? That is answered by this court, fundamental. They said no, you have not transferred your sovereignty in terms of only instrument of accession. You transfer it only by way of merger agreement. When I concluded,
what is superior? The Constitution of, what is superior? The Constitution of India?
Of course, it's Constitution of India, but there's no doubt about that.
Constitution of India is the merger agreement.
52.
The
Not
instrument.
merger agreement, instrument of accession. But with 370 in it. If it was no 370, it was different. My lords
Ultimately, come down.
understand your lordship's mind that one is constitution of India is there. Your instrument accession goes, your sovereignty goes, your everything goes.
Ultimately, it's
But
C7.
it doesn't seem to be like that because this is something which has been there for 69 years. This is how the governments have worked it out. For 69 years, from 1950 to 2009.
Now take a case of an Indian state apart from Jammu and Kashmir.
Yes.
There are restraints on the power of Parliament to enact laws with respect to anything in the state list. Even today, Parliament can't and cannot enact a law on the state list.
No, I'm with
Right?
your lordship.
Now, the reason I mention it is these restraints on the power of Parliament are equally consistent with sovereignty, where all the other Indian states, in any case, vesting in the dominion of India in India.
No, with
So a
respect, no.
restraint, see, the distribution of legislative powers does not affect the fact that sovereignty vests in India. So there are certain areas where the Parliament cannot touch something which relates to a particular state list item. But merely because Parliament is completely disabled from touching a state list item while enacting law, does that detract from the fact that all these states ceded sovereignty to the dominion of India? So what I'm trying to tell you is this, that restraint on the power to enact legislation is implicit in the scheme of the Constitution, the frame of the Constitution. Because we do not have a unitary state. But does that detract the fact that Parliament cannot enact a law on a state list item? Does that detract from sovereignty? It does not. It's just a fetter on Parliament. But there are other fetters on Parliament as well. Now you have the goods and services tax, which is another fetter which has been brought in by consent of the states and by Parliament. These are all fetters which don't dilute from sovereignty. Likewise, once Article 1, as Brother Justice Khanna said, says India shall be a union of states, and that includes the state of Jammu and Kashmir. Transfer of sovereignty was complete. Therefore, we can't really read the Article 370 Constitution as somehow a document which retains some element of sovereignty in Jammu and Kashmir.
I'm saying so for a simple reason. The example which my lords gave that there could be constitutional provisions with regard to other state legislatures that they can do, Parliament can make law, cannot make law with regard to that state legislature. Those limitations can be in the Constitution. But looking to Article 370, when it says concurrence of the government of the state, I say I am claiming it as a right of the state that my concurrence is needed. In the case of other states, where the Parliament may, as a matter of concession, say, look here, I will not do this for you, I will not do that thing for you. That's a matter of concession, not as a matter of right. I am claiming the state right, the state's right, not to apply any law of the Parliament unless I don't concur with that law. I am claiming the right.
I'll tell you, there are provisions in the Constitution which apply to concurrence of the states also. See Article 249. Parliament can enact a law on a matter covered in the state list, and it says that concurrence is required. Just see 249. Notwithstanding anything in the foregoing provisions of this chapter, if the Council of States has declared by resolution supported by not less than 2/3 of the members present and voting, that it is necessary or expedient in national interest that Parliament should make laws with respect to goods and services tax came in recently, or any matter enumerated in the state list specified in the resolution. It shall be lawful for Parliament to make laws for the whole or any part of the territory of India with respect to that matter while the resolution remains in force. That's how Parliament enacted a law for the Urban Land Sealing and Regulation Act. When the ULCRA came into force in 1975, it was preceded by resolutions by all the states because it was a state list item. So even on other states, Parliament has been given the power to enact laws on the state list, but it's subject to the concurrence. Here it's the Council of States, because the Council of States represents the state.
No concurrence required in this council.
It requires a resolution of the Rajya Sabha.
Resolution of the states. Choice is that of the states.
Therefore,
Act of the
though
legislature of
Parliament
the state.
ordinarily does not have a law, does not have the constitutional power to pass a law with respect to a state on a matter which pertains to the state list, if two or more states come together and say that, look, we want Parliament to pass a law, here again there's a concurrence required of the state for two or more states. So in that sense, concurrence is not something which is unique to only the relationship with Jammu and Kashmir. There are various shades of concurrence required in the constitution. It doesn't reflect on the sovereignty of the union. These are fetters. Now you see 246A, when it came in, as a result of the Goods and Services Tax Amendment. This is a classical case where the government of India or Parliament can do nothing without the concurrence of the states. 246A has completely redefined our notions of sovereignty in that sense. Because the states have now been given a vital role in financial matters. Parliament can do nothing unless there is a requisite majority in the Goods and Services Tax Council, the GST Council. So, in that sense, our notions of, the parliamentary exclusive competence, the state's competence, that's itself been, just as Call mentioned that yesterday, it's been an evolving exercise.
Looks like
So one thing is very clear, sovereignty was ceded completely to the Union of India.
What my lords are observing, which I understand, is that there are provisions in the Constitution where the states can also request the Parliament that you make the law for us, even if that subject of that law may be in the list too, where the state legislature had the exclusive power. But if two or more states decide so by way of a resolution, request the Parliament may make law for that. So it would imply that what is contained in Article 371, where it says that you will apply the law with the concurrence, it's in principle the same as there are other provisions, if I understand your lordship. So there's nothing so sacrosanct about it. I leave it for a minute. What about the constitutional provision for which concurrence is required and the president is to apply with modifications to me after that concurrence? Whether such a provision also exists for the states where they can request the president of India that you apply this constitution to us with these such kind of modifications, or it is not possible for the legislature to say so. So far as making of ordinary laws and so far as making of the constitutional provisions, obviously qualitatively they are different. In our case, concurrence is required also for the constitutional provisions, whether with exceptions and modifications that will also be seen. So ordinary laws, maybe my lord finds the support that there are other provisions, nothing great about it. But nevertheless, that will go against the text of 370 when it says concurrence is required for purpose of list 1 and list 3, whereas other provisions also provide that in a certain situation, not as a matter of routine, in a certain situation, the states can also request the Parliament to make the law. In our case, it is not a matter of routine that they could do so. For every kind of legislation which has been passed at the request of the government of the state, concurrence has been given. So there is no general concurrence.
Yeah, you made the point
succinctly. All the 54 constitutional applications.
Should we go on to the next point now? Because we've understood your
subject. So that also to allow just one more thing. Also that when these 54 constitutional orders have been passed, what is it that is given to us? And what was that was not given to us? In these 54 constitutional orders, which have been passed with a concurrence, there are some extremely important constitutional orders. Extremely important. Now, for example, take one. Article 3 provides for the alteration of the state's boundary, which has been read. I'm not dealing with that question, but I'm dealing it in a different way. For state of Jammu and Kashmir, you cannot do it. You cannot do it at all in terms of the 54 order. Now, why can't it be done for state of Jammu and Kashmir? The 54 order placed an embargo on it that till the state legislature will recommend for changing the name, for changing the boundary, you cannot do so. Now, this is a modification made in the application of Article 3 to us. Why was this kind of a provision made in Article 3? I cannot lose sight of the situation in which this Article 370A has come into existence.